Good morning, everybody. For those of you who haven't figured it out, my name is Gabriel Motzkin, and I'm the director of the Van Leer Jerusalem Institute, and it is my job to open conferences. I do this 3 to 5 times a week, but it's a special privilege and pleasure to open this conference because this conference is something that I actually care about. And I care about it because I think that the question of what happens to religion in the post-secular age is of extreme importance. Now, is there a religious resurgence? We think there is. We don't know. You never know. You go back in Protestant history into the 18th century, and you see that every 30 years there's a wave of some kind of religious resurgence. And if you look at the Catholic population in the United States, you see less people actually being Catholics than were Catholics before. But even if you assume that there is only a temporary religious resurgence, it still has legal and moral challenges in the context of the liberal state, because the liberal state defines itself as not depending on the religious order and defines itself as not enforcing the moral order through the religious order. In other words, the liberal state says, we enforce the moral order, and it is not religiously rooted. That's sort of an interesting idea because every other society in the world believes that the state and religion together enforce the moral order. Everyone, all the Catholic societies, all the East Asian societies, all of them see religion as one of the means by which human morality is enforced. This, in fact, has gone away with the rise of the liberal state, so you are left with some kind of ersatz religion in the sense that religion becomes a question of belief, of salvation, of things that are probably very important, but that have less to do with the way you live your life, with how you conduct yourself. That is a major change, and I am not sure, I can tell you this, whether this change is permanent or not. Human beings, and this is almost my last comment, need religion. The idea that they can get along without religion is silly. And whether there is a God or there is not a God, we are, I think, hardwired to believe in a God. It takes a lot of work not to believe in a God, to believe that we are in fact mechanistic beings. And I'll tell you this, that the mechanistic theory of the world can explain 4% of it. That's the amount of baryonic matter, that's like us, that exists in the universe. They have no idea what the other 96% are. I'm not saying these are spiritual particles or anything like that, but we are evolutionary. We have evolved to know the minimum about the world that we need in order to survive. It's very difficult to get beyond that. Well, with these rambling thoughts, I want to greet you all, and I hope we have a good conference, a conference full of debate and controversy, and I wish you the best of and most enjoyable of 2 days here. And I would like to ask Professor Cole Durham to greet you all. Thank you.
Well, it is a privilege for me and an honor to welcome everyone here. I'm here on behalf of the International Consortium for Law and Religion Studies that was founded by Silvio Ferrari, who many of you know, in Milan. I'm also here, of course, on behalf of my own center, the International Center for Law and Religion Studies at Brigham Young University in the United States. We're particularly grateful to the Van Leer Institute, to Professor Motzkin, and to the work of Joseph David for organizing this event. I think you have seen the program, and we have really an excellent set of issues laid out for us. I think we will find this extremely interesting. I want to just say that one of the things that I understand is going on here is effort to form a center that would work on these kinds of issues. I know what it's like to create centers at academic institutions, and it's not always a slam dunk, as we say in the United States, but certainly we're very supportive of this kind of effort. I can tell you that the international consortium is at work. We've just formed last year an African consortium for law and religion studies. I was in Nigeria about 3 weeks ago, and I have to say I was quite amazed. The law faculty there closed down so they could allow the students to come and talk about law and religion. We expected about 100. First 200 came, then they ultimately let 400 in, and there were 200 others they had to turn away. They didn't have a space big enough. We had about 300 people from the bar. So you could say there's a lot of enthusiasm. And this, I think, may reflect, I've seen similar things in Brazil or in various parts of Latin America. I mean, there is some kind of, I don't know if it's a resurgence or in some of those parts of the world that simply haven't experienced secularization the way it's been experienced in Europe. So it's very interesting to see these initiatives. We had another, actually a series of events that Tahir Mahmood helped us organize in India last fall. We're engaged with China, Vietnam. There was a major conference in connection with the G20 summit in Australia. So these kinds of things are going on around the world. Now, though the interaction of law and religion is as old as history, the discipline of law and religion is of relatively recent vintage, at least in legal academia, or maybe I should say secular legal academia. In the United States, the American Association of Law Schools first created a law and religion section in the mid-1970s. I served as secretary and later as chair for many of the years of the 1980s, so I had a first-hand experience of this developing in the United States. The 1980s, of course, witnessed the rise of the religious right in American politics and the resurgence of religion in the public square in the United States. This development was not uncontested, of course. Richard John Newhouse's 1984 book, The Naked Public Square, made the argument that the square should not be naked. That is, that public religion had a legitimate and indeed an important and constitutionally protected place in public life. Others, notably John Rawls, Bruce Ackerman, and many others, argued for a notion of public reason that would impose sharp limits on such public religious roles. This 1980s vintage debate has continued down to the present, and if anything has intensified in light of increasing recognition of what Peter Berger has called the desecularization of the world. Query whether that's happened or not. What our keynote speaker, Jose Casanova, described as the rise of public religion. What comparative scholarship has helped us to understand is the variety of forms that this resurgence of public religion takes in different parts of the world. We're also more conscious than ever before that the impact of secularization is more limited and more varied than originally thought by those who expected modernization to lead to the general withering away of religion. Moreover, with daily reports of violence in the name of religion perpetrated by groups such as ISIS and Boko Haram, persecution of Rohingya Muslims in Burma, to name only the most salient cases, and in light of increasing anti-Semitism, Islamophobia, the persecution of Christians worldwide, in light of all these things, questions of the appropriate way for law to deal with religion have taken on a new urgency. I'm thinking of the fact that the UN Special Rapporteur's latest presentation, which is, I'm not exactly sure whether it's happened or is about to happen, but it's on religion, violence in the name of religion, and the problems that creates. So that heightens our consciousness of these issues. Because of the unique cultural, religious, and historical setting in Israel, these questions take on contours here that are linked in unique ways to the protection, to national identity, security, and the protection of human rights. Because the religious heritage of so much of the world traces its roots here, and because of the particular travails suffered by Jewish people over the centuries, answers found here resonate with particular force in other parts of the world. We're conscious that many here have made major contributions to global discourse on the themes of this conference. We thank all of those here for participating and look forward to your insights and the contributions on these all too urgent issues. Thank you.
Thank you. Very briefly, thanks for everyone who came here this morning. Few words. When I'm asked what is law and religion and why now, where was it beforehand? And is it part of a contemporary trend of low end style? I'm not sure. I think that there is something else, as Cole hinted. We are all witnessing, in the last 2 decades at least, an increased interest in law among scholars of religious studies and an undeniable urge of lawyers and law professors to better understand religious praxis and believers, and hence to re-articulate legal attitudes towards them. It is, of course, not only a post-secular, post-rational, post-individual, or post-enlightenment phenomenon. It is more than that. It is also an acknowledgement that both law and religion are deeply dependent on historical experiences and particular epistemologies. Therefore, it is also about transcending historical experiences and internal point of views and identities, and as some would put it, it is about thinking seriously global. So when I was sitting the other day with a fellow friend, a law practitioner, who asked me, what is law and religion? A mutual colleague said, law and religion is like water and oil. Obviously, law and religion is not about a unified perspective or method, such we find with law and economics. I tend to describe law and religion as a field that contains various perspectives and methods, a field that treats various topics and problems, not necessarily new ones, a field that invites extended forms of thoughts that transcends particular context, a field that is stretched around 2 foci, the constitutional, i.e. the formal and exterior way of thinking, which deals with accommodation, regulation, and limitation, and a substantial one, which looks at law and religion both as resources of meanings that suggest reorganization and reorientations of meaning in our life. A mission that is well exemplified and done in the Oxford Journal of Law and Religion, done by our colleague Peter, sitting here, which succeeded to combine both foci and to allow both foci to have fruitful discourse. This is also an event to mark the efforts to establish an Israeli Center for the Study of Law and Religion, a framework that will allow lawyers, law professors, alongside experts in law, in religious studies, sociology, philosophy, and political thought, to think together on the interfaces or the interplays of law and religion. It is a plan to be a place where law and religion are taken very seriously and professionally, and that the combined effort will produce relevant knowledge and better understanding. This event is also part of a collaboration with my colleague who was with us, Professor Brett Sharas, on our initiation to establish a law and religion annual review. So I'd like to thank first and foremost to Professor Motzkin and the Leer Jerusalem Institute for hosting this event and for supporting the effort to go forward with my plans. Thanks also to Professor Cole Durham, the president of the International Consortium for the Study of Law and Religion, the sponsor of this event, and for the huge support and encouragement all the way down here, the inspiration he endows on me, and in fact, as many of in this room could tell, his leadership in so many projects around the globe. Many thanks, of course, to Professor Casanova for his kindly coming to deliver the keynote address. Many thanks to all friends who came from abroad, those who crossed oceans for this event, and those who crossed checkpoint for this event. I recall the opening to the preface of the Summa of Stephan of Tournai on the Gratian de Cartium, second half of the 12th century, when he was trying to invite his readers. So I'd like to quote a few sentences. If you invite two guests to a dinner, you will not serve the same fare for those who demand opposite things. With the one asking for what the other scorns, you will not vary dishes, lest either you throw the dining room into confusion, offend the diners. I invited two men to a banquet, a theologian and a lawyer, whose tastes diverged towards different desires. Since this one delighted by the trite things and the one longs for sweets, which of these should we offer? Which should we withhold? Do you refuse that either one request? He who will wrinkle, if I propose to discuss the laws which appear in the present work, one skilled in law will endure it with difficulty. He will wrinkle his nose, shake his head, thrust his lips, and what he deems to be known to himself, he believes to be unnecessary for the others. If I shall have begun to narrate the sacred deeds of the fathers of the Old and the New Testaments, a theologian will consider these remarks as useless and will both charge our little work with proclivity and accuse of ingratitude. Let them mutually come down a peg. Let them join together in healthy agreement. Let them pay the cost of something useful. Let the theologian not reject the laws under the pretext of sacred history, nor should the skilled in law dismiss with the huteness of the laws that is included in sacred history. With these things briefly having been poured for the dishes, for the washing hands, let me serve the promised feast to the diners. So I welcome you all to this table, to the study together, and to the study from each other. I highly encourage my Israeli fellows to get to know the fellows from abroad and vice versa. I wish us all a fruitful workshop in the 2 next coming days. Thank you.